Justice Jackson.
So it seems to me that the thrust of your argument is that we should look at this language in Title III and know that it is clear that Congress meant to allow these claims and judgments to go forward because Congress wanted these claims to proceed. The political and foreign policy circumstances were such that it was sort of punishing Cuba for having confiscated people's property. And I see that. But how do you respond to all of the evidence that we have that indicates that that really wasn't, in other words, the claims process really wasn't the primary thrust of this statute? This dovetails with what we were talking about in the earlier case, that when we see that what Congress was trying to do was to isolate Cuba economically by deterring third-party investment, then maybe when it set up this cause of action, it really was like, I'm just gonna let the regular rules operate as to whether or not you can actually bring a claim, because my focus, I'm impersonating Congress now, my focus is on this third-party investment problem that I'm trying to solve. You say, yes, but you set up a cause of action, so that must have meant that they also intended to abrogate sovereign immunity, and I guess I don't necessarily see why that's the case.
So, Justice Jackson, the thrust of our argument is not just that Congress set up a cause of action. It is that this is woven into the architecture of the statute. When Congress talks about who would be defendants, well, the only defendants it calls out by name are foreign instrumentalities. When it talks about specific rules for claims, the only particular claims it talks about are claims against Cuban instrumentalities.
Right, so it appreciated that claims could happen. I'm not faulting you or saying that that's not in there. What I'm asking you is whether it intended for those claims to happen under the circumstances that the FSIA would allow.
And I think the answer, the two best pieces of evidence on that for why the answer is no, one is the embargo we've already talked about, especially the embargo as codified in 1996, and two is section 6032, section 6082C, which says, apply the provisions of Title 28 that apply in Section 1331 actions, general federal question actions. That does not include the FSIA.
All right, let me ask you one more and then I'm done with this part. How does allowing this flood of claims to come in advance what I see as Congress's primary purpose? I think you get a little bit more mileage out of it if you're saying they absolutely intended to abrogate sovereign immunity with this cause of action, notwithstanding the existence of the FSIA, and they're not saying anything about that, because we know that they were trying to deter third-party investment, and somehow this is gonna help that. So help me to figure out how allowing this flood of claims is actually aimed at furthering Congress's primary purpose for this statute.
Because the primary purpose was not just third-party traffickers. The other primary purpose, probably the primary purpose, was the Cuban government itself as the key culprit here. And so preserving FSIA immunity would give a Cuban instrumentality a pass when a comparable private company would be on the hook for a trafficking claim, and the Cuban company would get a pass by dint of its relationship to the Cuban government. That is hard to square.
Maybe. I mean, there's foreign policy implications. The U.S. government is actually punishing
But
Cuba.
Justice Jackson, this is a statute that a couple provisions earlier has accused Cuba of, quote, cold-blooded murder. It is a couple provisions before that has said residential property is off limits unless you're associated with the Cuban government. Then we're going after your house, too.
And your point is that the statute is authorizing private individuals like Exxon to be like an AG to punish the Cuban government for that.
No,
conduct.
Justice Jackson, my point it is implausible that Congress would have wanted a Cuban company to fare better than a private trafficker, given all of the other